Hello. Testing one, two, three. Okay, we'll start in about, I think, 2 minutes. There's still quite a lot of people streaming in. Yeah, pun fully intended. Okay, we'll start in about, I think, 2 minutes. There's still quite a lot of people streaming in. Pun fully intended. Okay, guys, do you get your classmates to join? I think I only have 50 something viewers, so short of about 30, so quite a lot of people are not in yet. I'll wait about 1 more minute before starting. Okay, guys, do you get your classmates to join? I think I only have 50 something viewers, short of about 30, so quite a lot of people are not in yet. I'll wait about 1 more minute before starting. Okay, everyone, I'm going to start. Okay, and yeah, I think you can see from my screen today that there are a lot of enhancements. For instance, I have Totoro on the top left now, and I also have a whiteboard. So I'm gonna say hi to everyone on my whiteboard. Oh shit, my whiteboard is out of sync. Oops. Let me try again. Yeah. Okay, it should be better now. Okay, that's great, it works. As you all know, I never ever use the whiteboard, or I rarely use the whiteboard, so actually this is totally pointless. It's just to demonstrate my, I do not know, setup, I guess, which I'm quite proud of, yes. I mean, I managed to get slides, my face, and a whiteboard, and Totoro, and a live chat into a lecture. Which of your other teachers did that? Hmm? Yes. Okay. Anyway, back to business. So, I woke up this morning feeling like shit as always. So, I want to get this done and over with so I can go back to sleep. Yeah. Okay. Anyway, in the news, I think that all of you have heard that the circuit breaker or CB has turned into CCB. So it's going to be extended for another month. And in addition to that, the June school holidays have also been brought forward. Not something I'm looking forward to. I actually do want to go out during my holidays, so this is not really a holidays at all. It's pretty annoying. I bitched about it, and I'm gonna bitch about it more later. Okay, but anyway, yes, too bad, yeah. And I would say that this really encapsulates it. Okay, what I'm about to show you. Oh, oh, credits to Sophia for this. I was laughing non-stop last night over it. Yeah, it's quite brilliant. Yes, 11 upon 10 for creativity. Okay. Anyway, I'm gonna move on to the lecture proper. And a bit of recap before I move on to what is essentially a very new chapter for everyone. We are going to look at the International Court of Justice very soon, but before that, a quick recap as to the previous few lectures on this, which was on UN peacekeeping in the post-Cold War era. So we looked at how the end of the Cold War was a significant turning point for the UN and its peacekeeping missions in some ways, but it was not all completely nice and dandy. There were still some issues that continued. So the idea of change and continuity really comes in quite strongly here. Okay? And that was largely what we looked at for the last, I think, 4 or 5 lectures, case studies during the Cold War and also in the post-Cold War era. So, we looked at different factors that affected UN peacekeeping missions, such as the consent and support of the Security Council, the consent and support of the host state, the ability of the UN SecGen, the nature of the conflict, international trends such as the Cold War, great power rivalry, and big powers, blah, 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 blah. And that pretty much wraps up the entire UN peacekeeping chunk of your syllabus, which is probably the biggest chunk of all. Today, I'm going to move on to something entirely different. The International Court of Justice, or the ICJ for short, which is another aspect or another organ of the UN. If you recall from many weeks ago when we first started the UN, I mentioned that the UN had many different organs, and one of them was the International Court of Justice. So today we are going to look at that specifically. Okay, so we're going to look at the functions of the International Court of Justice and what powers does it have in resolving disputes between states, and also explain the nature of ICJ judgments, looking at some case studies along the way, and overall evaluate the effectiveness of the ICJ. So very similar to how we did the General Assembly, the Security Council, the SecGen's peacekeeping. We're going to look at what is the thing first, and then look at some case studies and then evaluate its overall effectiveness. So different ideas such as cause and effect and change and continuity will all come into play here. Okay, so this is where we are looking at. Okay, we have already covered the General Assembly, Security Council, the Secretariat, which is the SecGen. We have also covered this big idea of peacekeeping. And the final organ that we're going to look at for the UN is actually this, the International Court of Justice. So without further ado, let me zoom right into it. This ICJ actually has a physical location. It's located in The Hague, in the Netherlands, Holland. Okay, so some pictures of the building. Oh, nice building, nice gardens. Now can't visit, obviously, but maybe in future, when you do get a chance to go to Europe, you can pay it a visit. Okay, and as the name implies, what do you think the International Court of Justice or the ICJ deals with? Any guesses? Shit, my handwriting totally sucks. Yeah. I originally had a iPad and Apple Pencil, but a few days ago I passed it to another teacher who needed it more. Actually, I have the benefit of your poor GP and math and science teachers. They have to mark your physical scripts, your bloody handwritten scripts. They have to scan it in and then mark it with a stylus or an Apple Pencil or something. So I realized that my need was not as urgent as them, so I passed my iPad and Apple Pencil to one of them because I can actually mark or comment on Google Docs, unlike them. Yeah. So yes, spare a thought for them. I absolutely hate using a stylus or Apple Pencil or whatever. Actually, I hate writing in general, as you can tell from my handwriting. Okay, anyway, back to the question I asked. Yes, all of you are right. As Dheeraj pointed out, as Hao Jin pointed out, it deals with law. Okay, yes, it deals with law, and that is the critical distinction that I'm going to make here. That, as the name of the ICJ implies, it deals with legal stuff. So far, all those organs that you looked at, the General Assembly, SecGen, Security Council, Peacekeeping, they mainly deal with political and military conflicts. But now the ICJ actually deals with what we might term legal issues. Matters of international law, yes, there's such a thing. There's some codes of conduct that states on the international stage based on different treaties they sign practice. They deal with like legal matters when it comes to like territorial disputes, your like sea boundaries, your exclusive economic zone, your air control areas, all these things. And also overall the international obligations of states when it comes to different treaties they sign. So in a way, the ICJ deals with legal issues, okay, which is quite different from what you are used to so far, because the ICJ basically passes rulings on the international arena based on international law, which is a set of legal rules by which nations conduct their relations with each other. They might not always abide by it, but yes, there's more or less some general principles or rules or treaties that determine how nations conduct relations with each other in a legal sense on the international stage. Okay, so let's zoom in then to the functions of the International Court of Justice. Okay, first of all, Article 92 is what lays out what the ICJ can do in the UN Charter. So it's basically the principal judicial or legal arm of the UN. It passes judgment on disputes between states that choose to use it. Notice I'm stressing this already, that choose to use it. We'll get back to it later. And it also gives advice on legal matters to other parties within the UN when they need to seek help, NGOs, etc. They can pass advice on it too. Okay, so that in a nutshell is what the ICJ in theory is supposed to do. But as with all things UN, the reality is often quite different, as we'll soon see. Overall, the ICJ deals with more judicial than political matters, even though the two things do intersect now and then. But the ICJ's primary concern is on matters of international law and legal disputes, yes, as Atreyo mentioned, like Pedra Branca, rather than international politics between states, like wars and stuff. That's a bit less of what it deals with, though it does go into that now and then too. So for instance, it deals with issues of like frontier disputes, border disputes, maritime boundaries, pollution, exploitation of natural resources, hostage taking, asylum, migration, blah, 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 blah. That's what the ICJ deals with. And if we delve further into the function of the ICJ, actually, it's composed of 15 judges, usually appointed from different nationalities by the UN General Assembly and Security Council. They serve a term of 9 years, 5 retire every third year. Yes, a pretty complicated system. And in terms of decision making, it's also majority voting. And they pass judgments, or sometimes we call it arbitrations, which means judgments actually. They arbitrate disputes. That means they pass judgments on disputes, and these judgments are in theory supposed to be binding. That means in theory, nations need to abide by their judgments. But I'm going to go into the but later on. You will see that this isn't so clear-cut after all. In addition, they also sometimes offer legal advice to states. This can be binding or non-binding. Moving on. Okay, one of the things that we have already noticed so far is that it is actually quite problematic in a way, because yes, the ICJ can pass settlements. They can judge, they can arbitrate, they can decide. But at the end of the day, they don't really have a specific UN organ to enforce the settlement of all these disputes. And even though their judgments are supposed to be binding, there are a lot of loopholes, and at the end of the day, they are often non-enforceable due to sovereignty issues. Okay, so remember, they can arbitrate, that means they can pass judgment, but the enforcement part is problematic. Because enforcement, they need to rely on the Security Council. And remember all the issues with the Security Council. Okay? So that, in a nutshell, is the functions of the ICJ and its powers in interstate dispute settlements. Next up, I'm going to move into a closer examination of the ICJ along with some case studies, and then give an overall overview of its overall effectiveness. Why do I use the word overall so much? I have no idea. Now, so the nature of ICJ judgments is such that it relies on international law. Now, international law, unlike a nation's law, is not as codified and as clearly laid out as like a country's law, which means that it relies a lot on existing treaties, customs, principles, writings, previous decisions, and all that, rather than there isn't really like a book of international law. Rather, it's like a collection of general principles and treaties that nations have kind of abided by over time. So the very idea of international law is already a little vague. Okay, so keep that in mind as we go into looking at the nature of ICJ judgments. So, as I mentioned, the ICJ largely deals with judicial disputes. That means it doesn't go that much into the political matters, though sometimes it intersects. That means, things like peacekeeping, economic aid, sanctions, all these things, it doesn't really touch on those things. What the ICJ touches on is when you need some kind of settlement using international law, like Pedra Branca. Like, for instance, you have a border dispute between two states and both of you can't decide, but you also do not want to fight a war. So you go to the ICJ, ask the ICJ to decide based on like historical precedents, the reasons you have, get a legal decision on this dispute. So that tends to be what the ICJ does. The same goes for like if two nations have dispute over like fishing rights. The ICJ can rule on such matters in a legal sense too. Okay? Let's now look at some case studies of what the ICJ has dealt with over the years. And you will see from this selection of case studies that actually a lot of things that the ICJ dealt with are quite obscure, and in fact over the years the ICJ has not passed a lot of judgments at all. Later on I'll show you some stats in my final bit, which shows that actually over the last, I think, 70 plus years since the ICJ was formed, it has only dealt with like 100-ish disputes, and passed like 100-ish judgments, which is a very low number if you consider that it's 70 over years. Okay, it's a great job. I mean, you only need to decide on one thing a year or something like that. Okay, anyway, moving on. So, looking at some case studies of the ICJ, I've kind of classified it as positive or negative impact of the ICJ, but don't take it too absolutely. There are shades of grey in all this. So the first one we'll look at is the Britain versus Albania dispute over the Corfu Channel. Okay, I'm jumping the page number a bit, so actually the case studies are all summarized at the end of the chapter. Okay, apologies for that. That's how we chose to organize the chapter. So basically what happened was that this was immediately after the Second World War. British ships got hit by mines in the Corfu Channel off the coast of Albania, around the Croatia, Albania, Greece region. And so they conducted mine-sweeping actions in response, and they were pretty pissed off about this. So this dispute was brought to the ICJ, and the ICJ ruled that Albania had to pay the UK compensation for the mines. But at the same time, the ICJ also ruled that Britain was violating Albanian sovereignty by conducting mine-sweeping actions in response. So actually this was quite an impartial and fair ruling, in one sense blaming Albania for laying the mines, but also blaming the Brits for kind of infringing on the sovereignty of Albania. However, at the end of the day, this dispute kind of fizzled out because the UN had no way of enforcing this. The Security Council didn't want to do anything, and Albania refused to pay compensation, and that was pretty much the end of it. Moving on, another case study. This was probably a more positive one, so I've mentioned this a few times in the past already, so I wouldn't dwell on it too much. The Iranian hostage crisis of 1979, a great violation of international law because US hostages were taken in the aftermath of the Iranian Revolution, and this happened in the US Embassy. And to those of you familiar with how the world works, embassies are out of bounds, in a sense that you're not supposed to take hostages in embassies. An embassy is the sovereign territory of the country that owns it. So for instance, the US Embassy in Singapore is the sovereign territory of the US. Singapore has no right to do anything in the US Embassy. That's how embassies work. However, in this case, in the Iranian hostage crisis, US hostages were captured from the Iranian embassy. So this is a huge violation of international law. The ICJ tried to rule on this dispute, and they ruled that in a sense, you can't do this. Iran can't do this. But at the same time, they also cannot enforce hostages to be released. I mean, that's up to Iran, and if they don't want to listen, that's them. Yeah. But it nonetheless did exerted a lot of pressure on Iran because they were violating international law and kind of violating like the moral weight of the world in a sense. Okay, so this had a positive effect on the whole thing. Moving on, another case, this one is a classic example of how enforcement of ICJ rulings is problematic. Okay, this one again is quite familiar to all of you because we learned it in the Cold War, we learned it in the UN, and now we are learning it when it comes to the ICJ once again. So this is basically the Iran-Contra affair in Nicaragua. Sorry, my pronunciation. Nicaragua. Okay, during the Reagan era, if you recall the Reagan doctrine. So basically, the US was supporting the right-wing Contra rebels against the left-wing Sandinista regime in Nicaragua, and Nicaragua lodged a complaint against US violation of its sovereignty by supporting rebels in its own territory. And the ICJ ruled that the US needs to respect the sovereignty of Nicaragua. And guess what the US did? Bye! Screw you. Okay, they withdrew from the hearing and denounced the court. And the US can do this because let's not forget, as I mentioned just now, the enforcement of ICJ rulings requires the Security Council. So what do you think happened once this thing reached the SC? What do you think happened? Given the players involved here. Okay, yes, thank you very much, the veto. And you can see where the issues lie once again. Okay, but it goes beyond the veto in a sense because the US, given its position in the world, has the power to do this, to ignore all these kind of judgments because what can you do against them? Yeah, you can't do anything against them. You need them, they don't need you. So that's why, the US tends to act unilaterally in a lot of all these disputes. Okay, moving on. This one is quite obscure in a sense. Okay, it's in Africa. Once again, I'm going to bring up a map. So it's between Burkina Faso and Mali, two countries which you probably never ever heard of. Okay, those are their capitals there, which you again probably never heard of and probably shouldn't try to pronounce too. So I shall not try to pronounce them. This was a pretty straightforward border dispute between these two countries over the Agacha Strip, which is a stretch of land between them, the border there you see, and this erupted into war on two occasions in 74 and 85. Okay. And both sides agreed to submit the case to the ICJ for arbitration on this long-standing border dispute. And in the ICJ judgment of 1986, they kind of split the territory almost equally. It was a compromise solution, satisfactory, accepted by both sides happy, and that's that. However, what we notice here in this case, why it was so smooth, was because both sides consented to submit this dispute to the ICJ in the first place. Later on, when I analyze the effectiveness of ICJ, I'm going to mention that one of the requirements for a dispute to be submitted to the ICJ and why so few disputes get submitted to the ICJ is because both sides need to consent to it. That means both sides need to agree that yes, we are going to go to the International Court of Justice to get a ruling. If either one don't want, it's not going to go to the ICJ. You need both sides consent to even get the dispute judged. Okay, so in this case, both sides agreed to submit the case, and both sides also agreed with the outcome. And this is a classic case of how the ICJ can work. But it only works like this if both sides agree to send the case for, arbitration in the first place, and also if both sides agree with the outcome. Just now, the US example, you have already seen what happens when one of the sides, in that case, a very powerful side, refuses to agree with the outcome of the judgment. Okay, moving on. We also have this, the South African occupation of Southwest Africa, Namibia, as it's called now. So today this country is called Namibia, but that time, it was under the rule of South Africa. So basically, after World War II, despite not really having a claim over the territory, South Africa continued its occupation of Southwest Africa. And they also imposed apartheid laws on this new territory that they occupied. Anyone can tell me what's apartheid? I think those of you who take lit should be familiar with it. Do you all still do Age of Iron? I think in some years they did it. Is that one of your texts? Yes, guys, what's apartheid? Oh, you'll no longer do it. Okay, can, no problem. Okay, from what Hao Jin, Cliff, Corinne mentioned, I think Atreya also, I think yes, it's basically how to say segregation of whites and blacks in South Africa itself, and in this case in its territories too. So apartheid is basically a legal system imposed by South Africa that outrightly discriminates against the blacks within South Africa. So South Africa back then was basically ruled by a small group of whites who were the former colonial settlers there. And so they imposed all these laws on South Africa for a long period of the 20th century, which basically segregates and discriminates openly against the Africans within South Africa itself. Segregationist policies, as Corinne mentioned. Okay, so some pictures of how it actually looks is very terrible. I mean, you have like different roads and different passages for like whites and blacks. So you have areas where blacks cannot enter, white areas, and all these things. And also even toilets. You have like toilets which are for blacks only and toilets which are for whites only. So it's legal racism. Yeah, it's a legal system of discrimination, institutionalized and legal system of discrimination and racism. Okay, very, very terrible in a sense. Yes, it's ended now, thankfully, but let's not forget that it lasted for over 50 years. From the end of the Second World War until around 1990. So it was very sad. And as a result of South Africa's occupation of Southwest Africa, they also imposed all these apartheid laws on this territory. Yeah, no marriage between whites and blacks too. Okay, I think number of years back some lit students did this lah, but I think you'll no longer do it. It's a pretty famous book, Age of Iron, on apartheid. Okay, over the years, obviously the General Assembly, with the tide of decolonization, was pretty pissed off with the apartheid situation in South Africa. And so there were numerous advisory opinions sought from the ICJ in multiple years to seek some kind of judgment that this was illegal on the terms of international law. And finally, in 1971, yes, the ICJ ruled that the continued presence of South Africa and Southwest Africa, as well as the apartheid laws they imposed, was completely illegal. Okay? And this didn't change the situation immediately, but over the years, all these rulings by the ICJ kind of exerted a lot of pressure on South Africa, both over its occupation of Namibia and also over its apartheid laws. Okay, so yeah, it does have the effect of, once again, international pressure and the moral weight of the world behind it, even though full independence for Namibia only came in 1990. Moving on, another very, very famous one, the Spratly Islands. And I suspect all of you have heard about this during your ASEAN lectures. I hope you did. So, Spratly Islands, what's this about? Come. Heard about it before? Or in Chinese, Nansha Qingdao? Who are the countries involved in this dispute? Come, give me some. I'm sure you have heard of some of them. Okay, Malaysia, Indonesia. Oh, yes, China, the very important one. Also, Vietnam. Philippines, yes, Philippines too. Yes, okay, all of you are right. This is a multi-pronged dispute involving a lot of Southeast Asian countries, ranging from Vietnam, Philippines, Malaysia, Indonesia, even Thailand at some points, okay, but not directly. and China, the big brother to the north. And basically, this is a territorial dispute over maritime boundaries and also some islands. They are in the middle of the South China Sea. So basically, all these different countries that we mentioned all claim, actually Taiwan as well, yeah, all claim certain segments of the South China Sea. And you can see from the right image, okay, the image on the right, where their claims lie, okay, in colors. The red one is the Chinese claim. Okay, it's pretty absurd, let me tell you that. Okay, but yeah, that's the Chinese claim. So that is what all these countries claim, delineated. Mm? So blue is Vietnam, red is China, Philippines is purple, Brunei is there a little bit, yeah, Malaysia there. Okay, so China claims a huge chunk of the South China Sea as its territory. And this has kind of brought it into dispute with many, many different Southeast Asian states. Okay, so disputed by all these multiple countries for different reasons. Sorry, my arrows are a bit off, but for China and Taiwan, it's basically historical precedents. Basically, China dug up an old map, which it always refers to, with what it calls the 9-dash line. That means they show that this old map, since many hundreds of years ago, this South China Sea was basically China's. So they had a map showing that it's, belongs to them. Other countries, such as the Southeast Asian states like Vietnam, Malaysia, Indonesia, Philippines, dispute this because of what is known as the United Nations Law Convention on the Law of the Sea, or UNCLOS. So UNCLOS defines each country's sea territory, maritime boundaries, as extending out from the continental shelf for about 50 km, and then they have another further 250 km of EEZ's exclusive economic zone after that. So they define their boundaries based on this UN Treaty of International Law. So they dispute it for different reasons. Okay, so as a result of this dispute, it has flared up a few times over the years. In the 1970s, I think you studied that in Southeast Asia between Vietnam and China. And China in recent years has been building a lot of military bases on all these islands to stake its claim. Okay, and basically telling the rest to screw it. Okay, so there's some pictures of the airstrips that China has built there over the years. And even today, this was just, I think this was 5 years ago. I'm going to show you some recent ones later. You can see that there's still constant disputes over the South China Sea and the Spratly Islands specifically. More images of, Chinese flags being planted, Vietnamese flags being planted on assorted little rocks in the area. Yes, I know, quite absurd. One of the reasons why it's disputed so heavily is because they suspect there's oil and natural gas in the region, and also because it's a very strategic waterway that many ships pass through. So that's why they want it. Unresolved till today, and some of the kind of flare-ups, because all these nations don't really want to engage in an outright war over the Spratly Islands. So every time they have disputes, sometimes it ends up in situations like this, basically water gun fights. So yeah, you can see all the ships there. They don't want to fire at each other, so they spray water to try to chase each other off. Okay, yes, it's pretty funny. More recent images. This was just a few days ago, April 21 this year. So just 2 days ago, this dispute was again in the news, even amidst the coronavirus pandemic. Okay, as China started naming islands in the Spratly Islands. Naming them means you pretty much claim them already, in a sense. And obviously, this is disputed by the Southeast Asian countries, and also the US gets into this too, because the US often conducts what it calls freedom of navigation operations. That means to promote freedom of waterways, it sails its warships up everyone's seas and all that. So that's what the US did. Okay, they sailed their warships through the South China Sea once again. Okay, yeah. So still unresolved dispute till today. A final one that you may have heard of, which I wouldn't dwell so much on because it's more in your Southeast Asian chunk, but yes, this is also an ICJ issue. Okay, Petra Branca and the Southern Islands. Okay, basically this random pile of rocks in the middle of the coast of Johor, which both Singapore and Malaysia claim. It was kind of resolved in 2008, but it's kind of reignited in recent years again. Again, a really, really absurd claim. Okay, the middle rocks and the actual lighthouse of Petra Branca. If you're wondering how big is the actual, rock the lighthouse sits on, it's probably about the size of the school canteen. Okay, a bit bigger than the school canteen, maybe plus J block inside. Okay, so those were, in a nutshell, some of the different disputes that the ICJ has tried to arbitrate over the years, the case studies in a sense. And now, finally, we are going to look at an evaluation of the overall effectiveness of the ICJ over the years. And I'm going to point out different issues that affect how effective it can be. As you have probably realized by now, I don't have a very high opinion of the ICJ or of the UN in general, so I'm sorry if I'm a bit biased in some of the things I say. Okay, so I'm going to start off with limitations, obviously, of what the ICJ can do. And one of the biggest problems that the ICJ has is actually the second one here. Okay, but I'll get to that very soon. So first of all, the ICJ has limited jurisdiction in the sense that only states can be parties to a dispute and can submit disputes to them. So only states, all those like organizations, companies, giant MNCs and NGOs can't. Okay. Secondly, and what is probably one of the biggest problems of all with the ICJ is that its arbitration is non-compulsory. That means both disputing parties or more need to consent to submit the case to them. Like in the case of the Spratly Islands, China does not want to submit the case to the ICJ. And so very little can be done by the ICJ to pass rulings. Yes, they tried to pass a ruling, but China never consented to it. And this is one of the problems, that the ICJ needs states to first consent to submit the dispute to them. And this often results in some parties unwilling to submit. Okay, the lesser ones are usually willing to submit, but the more major powers tend to be less willing to submit disputes to the ICJ. And this is a big problem already, because even though the ICJ can pass binding rulings, it's non-compulsory. You don't have to go to them. You can start a war with each other instead. I mean, yeah, just giving you an example. You don't have to both if you don't consent to sending the dispute to the ICJ, it's not going there and nothing happens. Okay? And another big problem that the ICJ faces is that even though just now I said that its rulings are binding, it is only binding or compulsory under certain conditions. It's only if states sign this clause, known as the optional clause, in the ICJ's charter. However, even though states sign this optional clause, they can still attach reservations or caveats to it. For instance, they can say that, oh, I accept ICJ arbitration judgments as binding and compulsory only if So you can see how it's very difficult already. Because not only do states need to sign this in order for the ICJ's rulings to be compulsory and binding, states also have the right to attach parameters to it. So the US has this famous amendment known as the Connolly Amendment in 1946, which is brilliant. It says that they will accept the optional clause, except that the jurisdiction of the ICJ would not apply to disputes that are within the domestic jurisdiction of the US as determined by the US. What this means is that they will accept your rulings only if we determine that it's not within our own legal kind of sovereignty, which is hilarious. Basically saying that we will accept it only if we decide that it's not infringing on our sovereignty. Okay, so you can see how the optional clause itself has a lot of problems. And so why, even though ICJ judgments are binding and compulsory, there's a lot of problems to it because of states attaching reservations to the optional clause that they sign. Yes, you've got to be kidding me. Oh, the kitten moves. Finally, another big problem, another big limitation of the ICJ is that enforcement relies on the UN Security Council. The ICJ by itself does not have enforcement powers. So it relies on the Security Council to do so, and once it goes to the Security Council, the usual things. Great power rivalry, the veto, when the permanent members are involved, it gets very, very complicated. Okay, so yet another huge problem. Can judge, but enforcement depends on the SC, and the SC has a host of problems, as you have realized by now. Okay, yes, Mira has pointed out that kind of defeats the purpose, and yeah, in a sense. Okay, let's just say it's not the most useful thing around. Okay, furthermore, the whole process of engaging the ICJ is also expensive and time-consuming. Many countries also lack confidence in the court's ruling. Initially, it was Western-centric, but later on, it was quite It was more like third world sympathetic due to the changes in the GA. And overall, the court's decisions can be very unpredictable. It's very hard to tell how the court would rule based on international law because international law is quite vague. So that's why many states choose not to engage it in the first place because they feel that if they get the ICJ to judge, they will lose control over the outcome, and they do not want that. They want to maintain their own control over the outcome. They do not want an external party like the ICJ getting involved. Finally, some strengths because we need some balance after all, even though this is going to be very short. Okay, let's admit that it's still a useful process in influencing disputes. Like just now, I mentioned a few cases where they were useful in exerting pressure. Not too bad after all. A deterrent effect, international pressure on disputing states and all that. It can also be useful in like isolating specific border disputes and preventing the worsening of tensions. Okay. Overall, okay, let's just say that even though the ICJ plays a role in arbitrating dispute on behalf of the UN in international law, at the end of the day, most disputes in the world are settled mutually. States seldom go to the ICJ. And the UN record through the ICJ of peaceful settlement of disputes this way is really not strong. Okay, the ICJ has not dealt with a lot of cases over the years, and out of them, not a lot were successful as well. And ultimately, the ability to settle disputes really depends on the consensus between the UN and centers of power, like the great powers, in a sense, and also very heavily dependent on the international climate. Okay? So, at the end of the day, why do we still want to talk about international law then? I mean, it's debatable. I mean, it's useful, but how useful it is at the end of the day, it really depends on the willingness of world leaders to work within the UN and its organs like the ICJ, and also how this conflicts with the idea of national sovereignty sometimes. Okay, so yes, we study it, but yeah, we study it because it's important to know that such a thing exists, there's international law, but we also need to recognize the limitations of international law and the ICJ. Okay, some images of different disputes. This is actually the Senkaku Islands, Diaoyutai, between Japan and China. Yes. Hurry up and get out. Okay, more water gun fights. Oh, pew pew pew. Yep. Okay, this wraps up my lecture on the ICJ for today. So you will need to do a quick exit pass. But what we have done so far is to look at the functions of the ICJ, the nature of ICJ judgments. We looked at some case studies as well, and we also briefly evaluated the overall effectiveness of the ICJ. So before you leave, please make sure that you do the exit pass. It's embedded onto the History Google site under e-lectures, and I'm also going to link it in this chat itself. Okay, so make sure that you complete the exit pass before you leave. Okay, so do complete my exit pass. I'm going to paste it in the individual class chats too. So make sure that you complete it. You can also access it through the, what's that called? The History Google site. Yeah, it's there as well. Okay, do complete the exit pass. I heard that my exit passes are too easy, so this one is a bit more challenging. Requires that you actually listen. No, I still have one more lesson before I can sleep the rest of the day, which I really want to. What should I have for lunch? Do you want to vote on lunch? Okay, can let's do a vote. What should Mr. Gold eat for lunch? Fried rice, vodka, then later at night lah, maybe, yeah. Yeah, not McDonald's, very sad. No more bubble tea! Okay, I know all of you are going to judge me, but I was one of those that went to buy bubble tea last night. Okay, please do not let this leak out of this chat. I mean, this lecture, but yes. Do y'all see the fight that erupted over bubble tea last night? There's this video going around. It's quite funny. So you can see, out of the things that can start riots in Singapore, bubble tea is one of them. Okay, guys, once you're done with the exit pass, that's all for today. I hope you enjoyed the lecture. Actually, I'll miss streaming lectures. It's quite fun. Do you want a tour of my house? Okay, I guess that's it. I don't want to hold you all back because it's 2 minutes to your next lesson. So thank you very much. And bye. Do remember to finish the exit pass.